So let's talk about Mark and Harlan. Let's talk about trial attorney success principles and how to deal with negative press.
Well, let's start off with attorney success principles. Well, first of all, welcome, Mark. It's such a pleasure to have you here, and I always love interacting with you. You're always on your game. I guess that's because of all the practice that you have. But you know what's interesting about what you do? Well, I know we have a lot of PI attorneys, on the line here. It's kind of interesting that when you're dealing with domestic divorce, family issues, and criminal issues, you're in court every day. Every motion, every breath seems to be a court response, opposed to where a personal injury, it is definitely a negotiation, but you're not in front of a judge every day, and your energy in front of a judge, in front of a jury, is unmistakable. What are some of the trial attorney success principles that you're going to stick with? And we're going to spend the majority of our time dealing with negative press, but let's get these pillars on the table and make them very clear as to what your principles are when you're in court every day.
Sure. Well, again, first, it's great to be here. I appreciate the invitation. I love doing this stuff. I just love talking. I remember when I first started, I loved watching the lawyers who seemed to know a bit more than I did. Now, maybe out of repetition, a little bit of experience, hopefully I can sort of help with some of my experiences and help the younger lawyers out there to, who really love this profession to get better at it. So here's what we're going to do. We'll start with the pillars, as Harlan said, of what good lawyering is. So let me start with sort of what not to do. Here's one rule: stop being a lawyer. I remember when I was in college, loved wanting to be a lawyer. Then in law school, they trained us how to be a lawyer and ripped us apart to make us better and bring us down to the lowest common denominator, because we didn't know how to think as lawyers and we didn't know how to speak as lawyers. But then as you get further into the profession, what I realized is being a lawyer is really good when you're hanging out with other lawyers. And when you want to impress those lawyers and let them know, the big words that they're saying. And, and you stand that way, you talk about your car, you talk about your most recent win, because after all, we never lose cases, at least not when we're talking to people. And it's great. And it's really good ego boost, and you feel great. And you get to say, I'm a counselor at law, or I'm a lawyer, or I'm an attorney. And that's all great. Do not be a lawyer when you are trying to deal with people who are not lawyers. So don't try and be a lawyer in a negotiation with a mediator. Yes, there are lawyers around, but you really want to get across the idea of who you are as a person. And more importantly, you're really not there for your own ego. You are there for your client's position. So it's great that you have the abilities, but as a surgeon is not supposed to just start cutting into people because they know how and where and when to cut. You're not supposed to do it unless you absolutely have to. I don't think lawyers are supposed to be the arrogant lawyers that we have been trained to be when necessary in the past. I think that if I had one piece of advice to give to a young lawyer, it would be try not to act like a lawyer. And we can do that in a number of different areas. Let's talk about the most significant area. I mean, I love trials. My nirvana is to get in front of a jury, but even that means maybe once every month or two. So we don't spend an enormous amount of time. But since jury trials are sort of the pinnacle of how to be a lawyer and how to be a good lawyer, let's talk about jury trials for a second. You start using big words and puffing yourself up and sticking your chest out because you're a lawyer. Wear a very nice gold watch. You're going to lose the jury before you even say your first couple of words. What you need to do is be able to come across to a panel, not only the jurors who are sitting there, the 6 to 12 who you've picked, but the 60 or so that you're picking from, and talk to them the way that they're going to understand. Talk to them the way they're going to relate to you. Talk to them, quite honestly, and this sounds almost improper to say it this way, talk to them on their level, not your level. Most jurors have a reading comprehension and a comprehensive level of, 8th grade, 10th grade. It's not an insult. that's just where the average person's learning abilities sort of plateau out, because that's where they've learned most of what they need to learn to get through life. And if you start walking in and talking about college and law school terms, you're going to lose them. So I guess, Harlan, to start with, well, one principle is try not to be the lawyer that you think you are deep down inside, because you are losing your audience.
Well, I think that goes with, with everything. I mean, most people want to puff up their ego and want to make them sound smart. I wake up every day and Patty says to me, my wife says to me, she says, be interesting, not be interested, not interesting. And so you're forming that relationship. I mean, that's really good advice. One of the things that I've always said, and you and I have talked about this many, many times, in advertising and in communication, is talk to the public the way you would a jury, which is tell a story. I think it's all about relationships. So what you're saying, your biggest principle, which your biggest pillar, Mark, is be relatable, be humanistic, talk to the public the way you would talk to the jury as if they were your family. In essence, I know I'm paraphrasing that. We forget about that, and we certainly forget about that in the advertising. Hey, I want to this is a good opportunity to move into one of my favorite topics to deal with, and particularly with you, because you're always in front of the public, through CNN, through your press conferences. You have a renowned reputation of mastering the press. I say that, I'm not patronizing you. If anybody saw you on the stage with the Zimmerman case and a number of other cases that you've been involved with since, you have a way of working with the press. And because you're a defense lawyer, a lot of negativity comes back at you.
Sure.
How the heck do you deal with it? And one of my opening questions is when does that negative press begin, and when do you begin?
Right. So first of all, I will credit my Irish Catholic upbringing and my mom and my dad. You were not trained to be egoist in my family. You were trained to get your chores done, get your work done, go to school, get your grades and things like that. So literally, I sort of joke, my dad, who was 36 years or so with the New York City Fire Department, POW in World War II, he just had a calmness and a sense about him that he wasn't arrogant. He was very intelligent. We used to have vocabulary wars back and forth where he would challenge me. He was an intelligent guy, but he was not arrogant. And that's sort of in my DNA. I would love to say that I trained myself over the past 30 years of doing this, and that's where it comes from. But it really comes from my heritage. So it was sort of easy for me to look at a case and say, this is really not about me. This is about the client, and or it's about the system. People say to me when I do my criminal defense work, how do you represent somebody, when they're guilty, or when they did this, or they are accused of that? And I say this and I mean it, I don't represent individual clients as much as I represent the system. We have a constitution that says my guy or my woman is innocent until proven guilty. And I train prosecutors, in effect, you will get your conviction only if you get it through me. So if you look at it from that perspective and take your own sort of ego out of it, the idea of how you handle negativity in a criminal case. Look, when I train prosecutors and judge and lawyers on how to handle the press, first thing I say to criminal defense attorneys is stay the hell away from it. A media and press is never good for a criminal defense case, because the media now is only, sound bites and real quick and get the emotional stuff out. Never do they spend the time that is necessary to really get into the nuances of what a true criminal defense case is when you look at it from a constitutional perspective. But with that as a background, what do you do and how do you handle it? So here's what you have to do. One, you have to maintain your credibility. I'm not saying that for your own ego. You have to maintain your own credibility, because your credibility is going to pour over or drip over onto your client. So if you go up there and start arguing and espousing things that you cannot prove, or things that the evidence that's already out there obviously disproves, all you're really doing is telling them not to believe you. If they don't believe you, they're never going to believe your client. The focus that you have on every time you get in front of a camera, like this or the bigger black ones that you have to look at with CNN or ABC or wherever, is you are looking at your potential jury panel. If you're not doing that, what are you doing in front of a camera, right? So what you need to look at is you are talking to your potential jurors, and you have to maintain your credibility with them. So if your client is on videotape robbing the bank, running out, looking up at the camera, do not say he didn't rob the bank. You may have a reason why he robbed the bank, or you may not want to talk about him robbing the bank, but you don't want to lose your credibility, because look, those jurors who are there are a lot smarter than we want to give them credit for. They know what's going on. They will follow your instructions. They will listen to the judge. But if you lose them on a common sense ground or a credibility ground, you're going to lose yourself, which means you don't get those 4 or 5 or 6 or 7 percentage points, which is really all that counts in most jury trials. You're going to lose some of that. And most importantly, you're going to lose it on behalf of your client. Because if you're not telling the truth, if you're caught in a white lie or trying to lawyer your way around an undeniable fact, they're going to say that your client is doing the same thing. So
Mark,
maintain your honesty.
let me ask you, how do you deal with correcting false information in a press conference? You know, it's a good segue what you're saying. You want to maintain your credibility. You know, you don't want to look like a fool and start arguing, you know, with the press. But you got false information. How do you correct that? Where do you start with that?
You educate. And the nice thing about what I just said about you educate is that it's a completely protected position to be in. So the prosecutor comes out and says, he's guilty, blah, 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 and he did it, and this is horrible. And you just say, ladies and gentlemen of the press, let me just tell you what is going on here. We have a process. The process begins with an arrest. It doesn't mean very much. It just means we get to move forward on the case. And then we have discovery. Discovery is a process where we get all the police information, and then we get to question it. That's what I do as defense lawyers, to make sure the prosecutor did what he did right. And then we're going to see to make sure the search was correct and the arrest was correct and the DNA is correct, whatever else it might be. This is the way the process goes. So when Mr. Prosecutor runs out here and says guilty, 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 I don't know why he is rushing to a judgment that only a jury can decide, but I'm not going to. I mean, just like that, you can take something that is bad, because the bad is coming from the defense attorney in a PI case or a prosecutor in a criminal case, and say, you know, let's just let him yabber if he wants to, but let me talk to you about the process that we're in. And all of a sudden, you become what I teach in my jury selection seminars as well. If you can become the guide, the person who they can listen to or puts them just slightly in the right direction, then it's confirmation bias. We deal with it in jury selection. If I say something that you like, Bill, if I say to you, you know, I really like my sundaes with chocolate ice cream, because I know Bill likes chocolate ice cream, Bill likes what I have to say. So if I say to Bill, I like my sundaes with chocolate ice cream and a lot of whipped cream on top, all of a sudden Bill is going to like whipped cream more than if I said, you know what, chocolate ice cream is bad. You have to have coffee ice cream, right? And we have to bring that into the way we present ourselves at every moment that we are acting on behalf of a client. And you should only be acting on behalf of a client from the moment you wake up until the moment you go to sleep.
You know, you always seem, and I think that you're always prepared. You know, when you get in front, I remember in the Zimmerman case, there was another lawyer that initiated the case and what have you, and I was watching the press, and then all of a sudden the case comes to Mark O'Mara, and he's got a command of the, of the situation. You seem like you were very organized. You go into this. How organized are you? What's your prep for a press conference?
Prep is 90% of anything. I mean, and I always make the suggestion of a surgeon. A surgeon knows where to cut, but a surgeon who's not looking at x-rays and blood tests and lab results and all that, that's pure arrogance. Can you imagine a surgeon going in and going, don't worry about it, haven't seen the x-rays, but I'm a surgeon and I know where the appendix is, I'll get to it. No, preparation is 90% of it. The 10% where you get up there and get to do one of these in front of a camera, that's great, but you have to have everything ready. You have to have thought through everything that might come at you, because some journalists, and don't forget, nowadays, any journalist with any person with a cell phone can call themselves a journalist, so they're not bound by any journalistic ethics. You have to be ready for that. You have to be prepared. What I call it is just devil's advocacy. And Harlan, I've done it with you. Bill, I've done it with you. You know, if we're going to talk about something, I'm going to take the opposite approach. Well, we should have the seminar today and we should talk about this. Well, wait a minute. What about if clients really want to hear about this? Or if the attorneys are real? Because only within that conversation, within that sort of machinations that you go through, do you open up your experience level so that when somebody does say something like, well, wait a minute, what about this? And I heard that he said this to that person. You can say, you have your answer because you've thought it through. Again, it's that relatability that is the opposite of the other end of the spectrum from arrogance. You walk in front of the camera thinking, I know how to talk to a camera. Look, I know how to talk in front of a camera. I have done it for a long, long time. You can put me in front of a camera and have me talk about, deep water oil drilling, and I probably won't make a fool of myself because I know how to present. But what I'll really do is make sure that I don't say something that is provably wrong. So I'll talk about deep water drilling is probably in water, right? Stay within, that you can't get burned by it. And that's sort of an insight on how to handle the press.
What's your biggest advice for our audience in regards to organizing a press conference? Maybe trying your case in the press, which I know you don't want to do, but it's a reality of life.
Well, yeah, you should never try your case in the press unless you have to, and that's sort of a non sequitur, right? If the case is already in the press, then you have to try it in the press. It goes back 25 years ago that the Supreme Court first told us in a number of different cases that you not only have the right, but you have the obligation to present your client to a press that already exists out there to try and undo some of the negative influence that they have. So you have to do it. So what do? You can't just say, I got a big case in, here's my press conference. You really have to be willing to work with journalists and local, regional, and if you can get to it, nationwide journalists and reporters who you already have a relationship built up. So look, it is not a bad idea for you to say, look, I'm a young lawyer in town. I got some criminal defense cases or PI cases. Let me go take a reporter out to lunch. You don't say anything other than I want to make sure that I have someone I can talk to in case I have a case that might be worthwhile talking to the press about. So you lay those foundations, you have those relationships so that when you have a case, again, your press conference should be short, quick, to the point. Don't say too much controversial because you never, ever want to have to say at the next press conference, I'm sorry what I said at the last one. Keep it to the point where it is completely defendable, and also realize talking like this does not work. Here's the way you talk to in a press conference. Short press conference sound bites. We are here because of this. This is what it's about. And the reason why is because they don't put you on air for 10 or 15 minutes. They put you on air for 10 to 15 seconds. So understand that, again, as lawyers, we love talking in paragraphs. You can't even basically talk in a sentence when you're in front of a camera. You got to talk in sound bites.
So it's all really controlled statements. So that you don't get in trouble. I think that what I'm hearing from you is and the most important takeaway is that you do not want to be in the situation where you have to say, that's not what I meant.
Yeah. And we see that all the time. And here's another part of the problem. And I don't want to take more time because, guys, I can talk about this all day long. We are now living in an environment where our populace do not trust anything that is said anywhere on TV, right? So 5, 10, 15 years ago, maybe politicians will listen to a lot more. They're not now. Now, everybody is aware of fake news. Everybody is sensitized to it. Everyone's aware that we're real polarized. So unfortunately, some lawyer like me gets in front of a camera and says, blah, 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 my guy's a nice guy. And there's this thing in the back of their head, back in the limbic part of their brain that says, you may not be telling the truth. We have to understand that that's the environment, the the journalistic environment that we now exist in, and you have to be able to modify how you present in that way, which is again why I think it's so important to maintain, as Harlan has said, that sincerity as to how you present. Stop being a lawyer.
How do you, I think this is my last question. I think we're going to be running out of time, right, Bill? Let's talk about social media for a minute. I mean, that's playing a tremendous amount of, a tremendous role. When you started out in this business, when you started really gaining momentum as an ace, criminal attorney, we didn't have to deal with social media, but you do today. And so how do you play with that?
Well, it's a massive change. It's going back in the days where you didn't advertise, then yellow page advertisements, then billboards, and then radio, then TV. Look, social media is the town square of today. Nobody walks around the lake and talks about things. No one sits in the town square anymore. If you are not vibrant, not only aware, but vibrant in your social media presence, then the only thing that you're going to get is those referrals to you from people who know you. Okay, great.
Mark, I see you, on social media, very, very often, because you're a spokesperson on CNN. You're a go-to guy. You believe in press conferences, or you believe in dealing with the press in a very forward way. So your press conferences are on social media. And I go back and I take a look at the comments that people make, because you have no control of what people are how they're gonna react and how they're gonna say. And they're all over the lot. Are you responding to those? Are you not responding? I think that's where where people have the biggest issue with social media. How do we respond to social media? How do we hold our press?
Yeah. So my attitude is that I don't respond to most of the craziness that is on social media. I do look at it because I think, in the Zimmerman case, we had a Twitter account, absurd as that sounds, only because we had to stick our finger into the torrent of information that was flowing by us, so that we had to know. But we learned an enormous amount, because those people, again, are potential jurors, always the filter. So you hear what they're thinking, hear what they're saying. Now, I will on occasion, and you'll see it on my comment responses, if someone says something that is not just, I hope you die, if it's something realistic that I can respond to, I will say, look, this is what I said. This is your interpretation of it. And you'll see, I would sometimes take paragraphs to respond to one person, only because I really believe that is a good perspective to maintain in my head, that if there are people out there who are misunderstanding or have a legitimate gripe with what I say, even though I'm not going to maybe change that person's mind, I want to keep that awareness that I have to have that sharpness of how I present in the future. And
so you are responding to social media when it's appropriate, and you feel that you can make your point, because you're not really responding as much to that individual, but you're responding to the public and stating your case. One last tip for all these young lawyers that are out there: should they create their press conferences or get sucked into them?
Create it. You should do nothing but create. Look, and I say this to young lawyers: whatever it is you're doing, it's your client, it's your courtroom, it's your motion, it's your hearing, it's your trial. If you're not creating it, it is creating you. And it is so much easier to take control and to create it. Now, yes, there are judges who are aggressive with you, and yes, there are prosecutors who are aggressive with you. It's your case, it's your trial, own it. If you're going to have a press conference, take your time. Do it well, do it right, know that it's your case, know that it's your client, know that you are going to win. Maybe not this case, but as we start keeping track over the next decade or so, you will be a winner. And the way you do that is by acting that way now. Don't get aggressive, don't get arrogant, be only there for your client's benefit, but that you will win more cases by being affirmative in how you present yourself on social media, press conferences, and to the public.